civil or public service. 2, an order of this honorable court reinstating the claimants for their appointment being wrongly terminated. 3, an order of this honorable court directing the defendants to pay the claimant all their entitlement owed them before April 2017 and from April 2017 until the date of judgment, which is today. 4, the cost of this suit, including solicitor's fee, put at 800,000 naira only. 5, the sum of 10 million naira as general damages. And 6, the sum of 30,657,000 naira, being the sum total of the salaries and entitlements of the claimants from the last time they were paid in January 2016 to the month of June 2022. It is the claimant's case with the amended statement of facts that the first claimant was employed in 1985 as a class teacher by the second defendant, while the second claimant was employed in 2004 by the second defendant, and the third claimant was also employed in 2006 by a letter dated 1st of August 2006. They were all employed and engaged by the defendants and posted to different places for their primary assignments. They have heard that in 2016, the present administration in Kogi State embarked on the staff screening service exercise, as at the time of the exercise in 2016, the first claimant was the principal of a government secondary school in Elele on a GL 16 step 8, and his basic salary was 223,000 naira. That the salary was paid in an uneven percentage, leaving some arrears in 2016. It continued that the second claimant was an administrative officer in 2016 on GL 12 step 11, based on a basic salary of 119,000 naira. The third claimant in 2016 was a clerical officer on a GL 7 step 8, and his salary was 51,000 naira monthly. Payment was also uneven, leaving some arrears unpaid. It is also part of the environment that the defendants stopped paying claimant salaries since the screening exercise, and that the salaries owed the claimants from the month of January 2016, when they were last paid, to June 2022 is 30,657,000 naira. It is their position that they have been receiving their salaries before the screening exercise, and on the basis of it, their employment was reportedly terminated. It continued that the termination of their employment is not in line with the procedure laid down in the public service rule, as they were not given any query or any notice of termination of 3 months salary in lieu of notice. They equally averred that the action of the defendants jointly are wrongful, null and void, arbitrary use of powers, unconstitutional, and causing financial hardship, mental torture, stock and loss of means of livelihood. Also, it has been so difficult in taking care of their family and dependents. The defendants, in response, filed their joint statement of defense. According to them, staff were screened in 2016 verification exercise, and their names were published in the national dailies and was released by the committee. Names of all affected staff who were not cleared were listed, and the reason for their non-clearance was stated therein. According to the defendant, the claimants were told of their offenses at the screening exercise, which led to their dismissal. It continued that the claimants were aware of the reason for which they were relieved of their posts. It stated that the first claimant was unable to produce original copies of his educational certificate, that the second and third claimant found withdrawing money outside their primary assignment, that the result of the said exercise carried in the newspaper came out with the letters of dismissal. Conduct of the open screening exercise, the claimants were found to have breached the terms of their employment, which was obvious to them at the spot. on the spot and serve query notice in compliance with rules of their employment. They averred that further that upon being told via the newspaper, the claimant from that period stopped work, that the claimants are not entitled to relief sought. At the close of pleadings, parties on the 17th of November 2022 intimated the court of their desire to adopt the argument of record procedure, which is pursuant to the 38 and 33 of the rules of this court 2017. By this procedure, parties have consented to dispense with the need for cross-examination, and the case is to be decided based on the pleadings and documents front-loaded before the court. Subsequently, parties were ordered to file their final written addresses. Parties actually filed their final written addresses and have reduced that into the body of this judgment. So I will now go straight to the decision of the court. After giving the case at hand an in-depth consideration, I'm of the respective view that the issues that will best determine this case are: one, whether the second defendant is a legal person who can sue and be sued, and two, whether claimant is entitled to the relief sought. With regards to issue one, it is the contention of the defendants, be it paragraph 2 of their joint statement of defense and their final written address, that the second defendant is not a juristic personality that can sue and be sued. Let me first state that it is the duty of counsel to conduct the case of his client to the best of his ability. See the case of CPC and INEC and other citation captured, the case of Inakoju and Adeleke citation provided. Then a counsel on behalf of the claimants, Austin Ubonio of counsel, was served with the final written address of the defendants on the 15th of August 2022, according to the proof of service at page 250 of the record. He filed his final written address, in this case on 23rd of August 2022. Then a claimant counsel, despite being served with the written address of the defendants, days before he filed his own written address, did not deem it fit to address this court on the issue of jurisdiction raised by the defendants in their final written address. He turned a blind eye to the issue of jurisdiction, which is a fundamental issue that touches on the competence of the claimant's case against the second defendant. The court was prepared to learn from counsel, but sadly enough, he starved the court of his knowledge by his lackadaisical attitude to work. I find it most irritating and inexcusable that a minister in the temple of justice and a professional in his capacity will overlook such an important issue in his final address. It is indeed unprofessional, unpatriotic for any legal practitioner in this line to fail in his duty to address salient issues of law, which may impinge on the vows of the court to adjudicate on the suit before it. Be that as it may, it needs to be stated that the issues of juristic personality touches and affect the jurisdiction and competence of the court. Thus, being the issue of jurisdiction, this can be raised at any time, and even for the first time at the Supreme Court. See the case of Eneo and Ngeri citation capture. Case of Ostankino Shipping Company Limited and owners, the MT Bata citation also provided. The case of Uyo local government and Akwa Ibom state government citation provided. A party who brings an action to court or against whom an action is brought must be a person known to law, that is a juristic personality. Juristic or legal personality can only be denoted by the enabling law. This can either be the Constitution or a statute. If the enabling law provides for a particular name by way of juristic or legal personality, a party must sue or be sued in that name. Put differently, juristic or legal personality is a creation of statute, and a party which seeks relief must comply strictly with the enabling statute. The law recognizes two categories of persons who can sue and be sued, namely natural persons and artificial persons. Say the case of Dairo and registered trustees of TAD Lagos citation captured, the case of Abubakar and Yaradua citation captured. It means that no action can be brought or commenced by or against any party other than a natural person or body of persons unless such a party has been given by statute expressly or impliedly either A, a legal personality under the name by which it sues or is sued, or B, a right to sue or be sued by the name. In the case of socio-political research, development versus Ministry of Federal Capital Territory and all the citation provided. According to the defendants, the first schedule of the Constitution of the Federal Republic of Nigeria, 1999, as amended, hereafter referred to as the Constitution, did not clothe any of the local government mentioned with juristic personalities such that they can sue and be sued. They maintained further that only a local government council so constituted under Section 7 of the Constitution can sue and be sued, and that there is a whole world of difference between Ibaji local government area and Ibaji local government council. I must say that this position of the defendants is very far from the truth and a misconception of the provisions of the Constitution. I'll proceed to explain my reasons. In the case of Calabar Municipal Government and Honesty, is a 2022 decision of the Appeals Court, wherein they held that for the purpose of maintaining an action in court, the plaintiff must state the government he is taking to court with sufficient particularity, and that the Constitution sets out the nomenclature of the components of government and conferred juristic personality on the components. According to the court, Section 3, subsection 6 of the Constitution provides that there shall be 768 local government areas in Nigeria, as shown in the second column of Part 1 of the first schedule to the Constitution, and 6 area councils as shown in Part 2 of the same schedule. Section 3.6 refers to the second column of Part 1 of the first schedule, where local government areas are listed. According to the Supreme Court in this case, for a local government to have juristic personality, it must include the word quote and unquote local. The court held that the appellant Calabar Municipal Government lacked juristic personality for the absence of the word quote and unquote local. The court was of the view that the proper appellation of the appellant should have been quote and unquote Calabar Municipal Local Government. Follows therefrom that what clothes a local government area with juristic personality in this country is not Section 7 of the Constitution as contended by the defendants, but by Section 3, subsection 6 of the Constitution, as well as the schedules thereto. I've read Section 7 of the Constitution relied on by counsel. It specifically deals with the establishment, structure, composition, finance, and function of local government councils as may be provided under a state law. It must be reiterated that every local government area has its local government council as established by its own law. However, the local government area itself is the creation of the Constitution and enjoys legal personality by that. Therefore, while local government council gets its juristic personality from its enabling law, local government areas get their juristic personality from the Constitution which created them. By the provisions of Section 318 of the Constitution, quote and unquote government includes the government of the Federation or of any state or of a local government council or any person who exercises power of authority on its behalf. Section 3, subsection 6 of the Constitution provides that there shall be 768 local government areas in Nigeria, as shown in the second column of Part 1 of the first schedule to the Constitution, and 6 area councils as shown in Part 2 of that schedule. Section 3.6 of the Constitution refers to the second column of Part 1 of the first schedule, where the local government areas are listed. Therein, in the second column of Part 1 of the first schedule, the local government areas of the state are listed, and this includes Ibaji. From the provisions of Section 3.6 and the second column of Part 1 of the first schedule to the Constitution, the local government areas listed must carry the appellation, quote and unquote, local government. Now, the second defendant in this case was sued as Ibaji local government area. This, to me, is the correct appellation of the second defendant. In fact, the second defendant on the authority of Calabar Municipal Government and Honesty Supra to have juristic personality does not need either the word area or council. What is important is the word local government. This is because it is government itself, which in this case is the local government area itself, as listed in the second column of Part 1 of the first schedule to the Constitution, that has juristic personality. So the contention of the defendants that only a local government council has juristic personality is a misconception of the concept of juristic personality of the local government areas under the Constitution. I believe council's misconception stems from the fact that council fails to recognize that local government area itself is different from the local government council. Local government area, and in this case, the second dependent, is a creation of the Constitution, as I've stated earlier, and does have juristic personality, while the council of the second dependent is itself a separate personality whose juristic personality is gotten from its enabling law. Local government area has its own juristic personality different from that of its council. In view of this, of its council, which is the legislative arm of the local government. In view of this, I say that I'm not swayed by the position of the defendants as same is unmeritorious. Accordingly, I find that the second defendant is a juristic personality who can sue and be sued. Now to issue 2. It is expedient for me to point out that the defendants in this case did not file a consequential amendment to their joint statement of defense after the claimant amended their statement of facts. The law is settled that upon an amendment of the statement of claim, the defendant is at liberty to amend his statement of defense without leave of the court insofar only as is necessary to meet the facts introduced by the amendment, where of course the defendant fails to amend his defense and his originating defense thereby, the original defense thereby stands as the defense to the amended statement of claim. Parties are brought to an issue on the amended statement of claim, thus where he fails to file a consequential amended statement of defense to the amended statement of claim, he cannot be taken to have joint issues with the claimant on the new issues raised in the amended statement of claim. See the case of Usman and First Bank and other citation captured, the case of Mobile Oil, Nigeria PLC, and IAL 36 Inc. citation provided. In essence, a defendant to a suit, just a minute. In essence, a defendant to a suit is not obliged to file a consequential amendment to an amended statement of claim if the defendant is comfortable with a statement of defense that it adequately responded to the amended statement of claim or facts. He did not file a consequential amendment. This is elementary law for which I need not cite any case. It is not only elementary law, but also common sense. See the case of Afemikai and others versus Stanbic IBTC Bank, citation captured. Next is the submission of LENEC Defense Counsel to the documents front-loaded in this case. LENEC Counsel, on behalf of the defendants, submitted in paragraph 3.11 of his final written address that the documents adheres to the amended process when short of legal requirements. He submitted that the document offend the provision of Section 104 of the Evidence Act, which required certification, that the letters from Ibadan Local Government Council, Ibadan Local Government Education Authority, and letter from Ministry of Local Government and Chieftaincy Affairs were not certified. First, it has been stated earlier that parties in this case consented voluntarily to adopt the argument on record procedure pursuant to the 38 Rule 33 of the rules of this court, which is to the effect that parties have dispensed with oral hearing of the case and consented that the case be decided on record, which includes documents front-loaded. Submission of LENEC Counsel is misplaced and misconceived in the sense that the requirement of certification of public document is for the purpose of admissibility of the evidence during trial and authentication of the documents, which is not obtainable in this case as there is no oral hearing that will necessitate admitting the documents. Counsel himself consented to the argument on record procedure, which means that he once the court tried the case based on the pleadings and documents front-loaded. Then the defense counsel's contention is not questioning the authenticity of the documents, which is the main reason for certification of public documents. The main purpose of certification of public document was succinctly captured by the Apex Court in the case of Goodwill and Trust Investment Limited versus Wheat and Bush Limited, citation captured, wherein the Apex Court held us, and I quote, the essence of demanding for a certified true copy of a public document is the assurance of the authenticity of the document vis-a-vis the original, unquote. See also the case of Emmanuel versus Kumana and others, citation captured. The second point is that a front-loaded copy of a document must necessarily be a photocopy or secondary copy, except where the document was executed in several parts or counterparts, and the party has many of the parts to exhibit in original forms. Then a counsel has had ample time to go through the documents and ought to have indicated in the schedule of documents he intends to object to pursuant to Order 15, Rule 3A and B of the Rules of this Court in his statement of defense when he filed it. It needs be stressed that the rules of court are meant to be obeyed. They are not therein as window dressers. They are to serve a purpose, and the compliance with same is germane to effective administration of justice. It is in the light of these and pursuant to Order 15, Rule 4.1 of the Civil Procedure Rules of this Court 2017, that I deem all the documents front-loaded by the claimants on record admitted without any objection by the defendants. This is the claimant case, that they were employees of the defendants and were employed at several dates. It is the defendant's submission via their final written address that the documents relied upon to establish the fact that the first claimant was employed by the second defendant did not support his affirmance, whereas his letter of appointment, pleaded, is said to be dated 11th of April 1985. The letter of appointment front-loaded in support of the affirmance is however dated 11th of March 1985. It was submitted by learned counsel on behalf of the defendant, but the two dates are irreconcilable, and the duty of the court is not to pick and choose as between the dates put forward. It was a third bit, paragraph 5 of the amended statement of facts, that the claimants were employed by the defendants at separate times and posted to separate places for their primary assignment. Paragraph 5A states further that the first claimant was employed in 1985 as a class teacher by the second defendant. The first claimant's letter of appointment dated 11th of April 1985 was pleaded. This fact was equally reiterated in paragraph 5 of the further and meta statement of oath of the first claimant at page 211 of the record. I perused the said letter front-loaded, and I find that it is dated 11th of March 1985 and not 11th of April 1985. And as such, the assertion of the defense counsel as to the discrepancies in date is correct. Must be pointed out that there is a difference between pleadings of a party and evidence. While pleadings are mere statement of material facts, which the pleader intends to rely upon in support or defense of the claim, evidence is the means by which the pleaded facts may be proved or disproved. In fact, pleadings are only the means or a vehicle through which the party can prove his case by legally acceptable evidence through the medium of witnesses, documents, or records. It follows therefrom that pleading is not synonymous with evidence. Averment in pleadings, however eloquently and brilliantly drafted, cannot constitute or take the place of evidence and cannot be used in determining the merit or otherwise of the case. Say the case of Enel Chukwu versus Okoye and another citation captured, case of Ojo and another, and Razaki and another citation provided, Elegusi and other versus Husseini and other citation provided. As such, it is not the pleadings, but the evidence in support of the pleadings that determines what a party has proved or disproved or failed to prove. The defendant's contention that the employment of the first claimant has not been proven because the letter front-loaded is dated 11th March 1985 and not 11th of April 1985, which was referred to in its pleading, has no place because the document itself speaks for itself. and it is the best evidence of itself before the court. See the case of Udo and the state citation captured, the case of Ahmed and Central Bank of Nigeria citation equally captured. The document itself shows that the date on it is 11th of March, 1985. And the date referred to in the pleadings cannot override the contents of the document and is not important in the determination of the merit of this case or what parties are proved or not proved. In my view, the appointment of the first claimant has been sufficiently proved by the said letter of appointment dated 11th of March, 1985. Therefore, the contention of the defendant is discountenanced. I have considered the letter of appointment and confirmation of the claimants at pages 216 to 221 of the record, and I find for a fact that claimants are in the employment of the defendant. And it should be stated clearly here also that the defendant did not deny the fact that the claimants are the employees of the government. It is equally the contention of learned counsel on behalf of the defendants that the first claimant has not shown that it was employed by the second defendant, as the document speaks for itself. It is worthy of note that the defendants in this case, who, as earlier stated, did not file a consequential amended statement of defense, by paragraph 1 of the adjourned statement of defense, admitted the claimant's affirmation in paragraph 9 of the initial statement of facts that the defendants are their employers. Thus, by the state of pleadings, the defendants have not joined issues with the claimants as regards the fact that the defendants are the employers of the claimants. The law is elementary, the facts admitted need no further proof. See the case of CPC versus Nadu, citation provided, VP Industries Limited and Cocoa Industries Limited, citation provided, Unique Limited and UCIC Limited, citation provided. Learned counsel cannot be making issue out of the employment of first claimant by the second defendant when the state of pleadings already show that the defendants, including the second defendant, have admitted that they are the employers of the claimant. Counsel cannot set up a case different from the one that has been made out in the pleadings of the defendants because parties are bound by their pleadings. See the case of FBN PLC and Standard Polyplastic Industries Limited, citation provided. ABBA versus ABBA AG, citation provided. Whose phone is that? Collected court police. Isaac and Emission, citation provided. Gogo and Ogwebu, citation provided. America Cinamide Company versus Vitality Pharmaceuticals Limited, citation captured. Besides, the documents on page 222 of the record is clear, and it's a letter dated 19th of September 2011, and it's in the letterhead of the Education Authority of the second defendant, clearly speaks for itself and shows that the first claimant was appointed principal UB Secondary School by the Education Authority of the second defendant. This clearly shows that there is a nexus of employment between the first claimant and the second defendant. Therefore, the submission of learned defense counsel in paragraph 3.4 of his final written address at page 256 of the record is discountenanced. The above finding leads me to the type of employment the claimants held with defendants. According to the claimants, both in their pleadings and the final written address, the employment is one governed by statute. The defendants have not challenged this fact in their joint statement of defense. In common legal parlance, an employment with statutory flavor is that employment where the procedure for employment and discipline are governed by statute. See the cases of Omagbemi and FBN, citation captured, and the notorious case of Olorun Toba Oju and Abdurrahim, citation provided. In determining what an employment with statutory flavor means, the appellate courts have held that it relates to employment in the public or civil service of the federation, state or local governments or agencies of government, including institutions and parastatals, wherein the civil service or public service rules apply or are made relevant or incorporated. See the case of Inadi versus National Ear Care Center and another citation provided. The notorious case of Shito Bay and Federal Civil Service Commission, citation equally provided. Other preconditions for the combination of employment with statutory flavor are as captured in the case of Kwara State Judicial Service Commission and Poland citation provides an apex court decision on this subject. Claimant by paragraph 15 of the amended statement of fact observed that their employment is regulated by the civil or public service law. They equally averred with paragraph 22 of the said amended statement of facts that the termination of their employment did not comply with laid down rules on appointment and termination of employment of public servants. Claimant by these averments are claiming the status of public servants and are contending that the procedure laid down for the determination of the employment of public servants are not complied with by the provisions of Section 318 of the Constitution. Public service of the state means service of the state in any capacity in respect of the government of the state and includes services as staff of any local government council, and F, staff of educational institutions established or financed principally by government of the state. Follows therefrom that any staff of any local government, just a minute, that any staff of any local government council or area and any educational institution owned by the government of the state are public servants. It is not in doubt from the pleadings of parties that claimants in this case were teachers employed by the local government area of the second dependent, and they are in the service of the first dependent. Thus, the claimants are public servants in Kogi State Public Service. This court takes judicial notice of the fact that the applicable law to Kogi State Public Service is the Federal Public Service Rules, which has been adopted by Kogi State government to employment in the state public service. It is not disputed in this case that the first defendant conducted a screening exercise of civil servants in 2016, in which the claimants who were employees of the second defendant took part, and which led to the dispute in this case. This equally clearly shows that claimants are in the service of the first defendant and part of the public service of Kogi State. It is equally not in dispute that it was after the screening exercise that the claimants were not allowed to continue to work in the several capacities they held prior to the screening exercise. Claimants by paragraph 16 of the amended statement of fact observed that no query letter was served on them to command their response if the screening exercise has found them wanting. That they equally averred with paragraph 17 of the amended statement of facts that they were never served any letter of termination of their employment or notice to show the purported termination of their employment. The defendants read paragraph 6 of the advanced statement of defense of that claimants were told of their offenses on the spot at the screening exercise, and the offenses leading to their dismissal were spelled out in the list released. It is untrue that the claimants were not aware of the reasons they were relieved of their duty. In the same vein, defendants read paragraph 13 of the advanced statement of defense averred that the dismissal of the claimants is in line with the laid down procedure and the circumstances in which it was carried out, being an exercise involving the entire workforce in the state. The circular specifying their offense and reason for their dismissal is enough without the necessity of issuing individual letters. First, there is no such document which purport to be a list release or circular before this court with the names of the claimants and specifying the offense or reasons for their dismissal. It is worthy of note that whilst the claimants are claiming that their employment was terminated, the defendants are alleging that the claimants were dismissed of their post. There is no document evincing either termination or dismissal before this court. Little wonder parties are loggerheads as to whether it was a termination or dismissal. In fact, the defendants in this case did not front load any documents in support of their case. There's a tried principle of law that a party that relies on the contents of the document to establish its case has a duty to produce the document before the court. See the case of Lufthansa German Airlines versus Berlin, citation captured. A party who relies on the document in support of its case has the burden to place the document before the court, especially where the document is not of such a nature that the court can take judicial notice of. In the absence of any such circular, this court does not believe the averment of the defendants in paragraph 6 and 13 of their joint statement of defense. Claimant read paragraph 23 of the amended statement of facts, averred that the wrongful termination of the appointment did not follow the laid down procedure of the public service rule, since they were not served any query, neither were they given any notice of termination or salary in lieu of same by the defendant, and since they did not commit any offense to the best of their knowledge to warrant the purported termination of the appointment or employment. In paragraph 9 of their joint statement of defense, the defendants averred that the conduct of the open screening exercise wherein the claimants appeared and where they were openly found to have breached the terms of their employment and which breaches were made obvious to them on the spot, and again carried in the screening report, served as enough warning and query and notice in compliance with the rules of their service. It is in my respectful view that the moment claimants were indicted by the screening exercise conducted by the first defendant, the defendants ought to have initiated the proceedings for dismissal or termination in line with the public service rules. This is because the employment of the claimants as public servants is governed by the provision of the public service rule. There's no doubt that the purported dismissal of claimants by the defendants is punitive in view of the alleged indictment of claimants by the screening exercise. Procedure for dismissal under Rule 0307 of the Public Service Rules is clear. And for the sake of clarity, it is important that I capture the provision of this rule here on the. It provides those, I quote, Rule 0307, unless the method of dismissal is otherwise provided for in these rules, an officer in the Federal Public Service may be dismissed by the Federal Civil Service Commission only in accordance with this rule. Officers shall be notified in writing of the grounds on which it is purported to discipline him or her. The query should be precise and to the point. He must relate the circumstance of the offense, the rule and regulation which the officer has broken, and the likely penalty. Serious cases which are likely to result in dismissal, the officer should be given access to any such document or documents or reports used against him or her, and he or she should be asked to state in his defense that he or she has been given access to such documents. The officer shall be called upon to state in writing within the period specified in the query any grounds upon which he or she relies to exculpate himself or herself. Query or preliminary letter shall be in the format shown in Appendix 2. If the officer submits his or her representations and the Federal Civil Service Commission is not satisfied that he or she has exculpated himself or herself and considers that the officer should be dismissed, he shall take such action accordingly. Should the officer, however, fail to furnish any representations within the time fixed, commission may take such action against the officer as it deems appropriate. 4. Upon considering the representation of the officer, the commission is of the opinion that the officer does not deserve to be dismissed from the service or deserves some other punishment. It shall impose on the officer such punishment as is considered appropriate. And where necessary, the commission may set up a court of inquiry, which shall consist of not less than 3 persons, one of whom shall be appointed chairman by the commission. Members of the board shall be selected with due regard to the status and the grade level of the officer involved in the disciplinary case and to the nature of the complaint, which is the subject of the inquiry. The head of the officer's department shall not be a member of the board. The officer shall be informed on a specific day. The question of his or her dismissal shall be brought before the board, and he or she shall be required to appear before it and tender any document he intends to tender. And if during the course of the inquiry, further grounds for dismissal are disclosed, the service commission thinks it fit to proceed against the officer upon such grounds, the officer shall, by the direction of the commission, be furnished with a written statement thereof, and the same steps shall be taken as prescribed above in respect of the original grounds. The board, having inquired into the matter, shall make a report to the commission, and if the commission considers that the report shall be amplified in any respect of that further inquiry is desirable, it may refer the matter back to the board for further inquiry or report. Commission shall not in itself bear witnesses. And if upon considering the report of the board together with the evidence and all material documents relating to the case, the Commission is of the opinion that the officer should be dismissed, such an action shall immediately be taken. If the Commission does not approve the officer's dismissal and does not consider that any penalty should be imposed, the officer shall be reinstated forthwith and be entitled to his full amount of salary denied him or her if he or she is indicted or suspended. If upon considering the report of the board, the Commission is of the opinion that the officer does not deserve to be dismissed, but that the proceeding disclosed grounds for requiring him or her to retire, the Commission shall without further proceeding direct accordingly. And finally, all disciplinary procedures must commence and be completed within a period of 60 days. In the instant case, there is no evidence that any of the above procedure was followed by the defendants in the purported dismissal of the claimants. No public servant can be dismissed in contravention of the above provision. The law is settled beyond argument that an employment with statutory flavor can only be determined in accordance with the procedure for termination or dismissal of employment set out in the rules and regulations applicable to the employment. Hence, any other manner of termination or dismissal inconsistent therewith is null, void, and of no effect. Amongst the horde of judicial authorities are the following cases: Obani and UBN PLC, citation captured; Controller General of Customs and others, and reserved, citation provided; notorious case of Lungi and FBN, citation provided; and also a notorious case of Bangui, University of Ilorin, citation provided. It is mandatory for the defendants to follow the procedure for dismissal of public servant as contained in the public service rules before they can validly dispense with the services of the claimants by way of dismissal. If the defendants intend to dismiss the claimants in view of the outcome of the screening committee, they must of necessity follow the procedure for dismissal as provided in the public service rules. I am therefore not swayed by the position of defendants in their pleadings, no matter how convincing. It is thus my view that failure to follow the above procedure is out of the case of the defendants and thus vitiates the purported dismissal of the claimants. It was equally the position of the defendants by paragraph 8 of the address statement of defense that the staff verification exercise involved all staff of the state civil service. The result of the said exercise carried in newspaper publications and the screening list release dispenses with the issuance of individual notices or letters of dismissal. The pertinent question at this stage is, can one say that the mere non-publication of claimants' names or publication of their names as part of the clear staff or on the unclear staff taken to have terminated the employment or dismiss them with regards to the status of the employment? Put differently, will it be sufficient to say that in view of the publication of the names of those cleared by the screening exercise, there is no need for issuance of letters of dismissal to at least communicate the decision of the defendants to the claimants, most especially where their employment is in view with status higher than that of an ordinary master servant? In answering this question, I will rely on the decision of the Supreme Court, Per Mohammed JSC of blessed memory in the case of PACN and Ofoyelu, where it was held as, and I quote, "The respondent, in my view, is justified in his defense that it was not communicated the retirement, even if it was. I think the communication was not done in accordance with the regulation as contained in SBK. Proper communication of a message in law has its importance. Where there is a failure to communicate, a break in communication or lack of communication, the whole purpose of the message is completely defeated. If any step or action is taken by the issuing authority in spite of the fact of non-communication or non-service, the step or action goes to naught and amounts to a nullity in law," unquote. From the above case, it is clear that non-communication of a decision renders it as a nullity. Also, any step taken after the non-communication will equally go to naught. Thus, the non-communication of a purported dismissal to the claimant of the alleged or purported dismissal has defeated the whole process. Equally, the step of stopping claimant salaries after the non-communication equally goes to naught. Besides, the point must be made that constructive notice of termination or even dismissal has no place in our law. Where there is no communication, the whole essence of the message is completely defeated, as an employee cannot be said to be aware of his dismissal without proper communication to that effect. See the case of Advanced Maritime Transport Nigeria Limited and Idigbe and other citation captured, the case of Mobile Producing Nigeria Limited and other citation provided. In fact, the Court of Appeal in the case of Boha and other vessels Silama, citation captured, held while relying on the English case of Isdak CYE versus Barat, citation provided that an essential part of the protection of employees is the requirement that they be informed of any possible breach of their rights. The doctrine of constructive knowledge has no place in the debate as to whether a dismissal has been communicated. It then means that an employee cannot be deemed to have knowledge or notice of his or her disengagement or dismissal until he or she has been expressly notified. Not went further that the correct view of the law is that an employment contract is brought to an end by a dismissal letter sent by or on behalf of the employer to the employee at his or her address and delivered to that address, and that it comes to an end on the date of such delivery, regardless of whether or not the employee was there at that time or later on that day, or did not see the letter. Flowing from the above, it then means that the claimants are entitled to be informed in writing of the termination or their purported dismissal by the defendants, most especially where they are by the status of the employment higher than an ordinary master-servant relationship. The mere non-publication of claimants' names amongst the cleared staff or even the publication of claimants' names among the uncleared without more cannot validly operate as severance of the employment relationship because the claimants do not hold their employment at will. As public servants, they enjoy a special status. Even when it was held that the employment was held to be at will, in the case of Oni and Governor of Ekiti State, the court held that merely announcing the dismissal or determination of the appointment of the respondent in that case is a nullity. In view of all reasons supra, I find that the purported uncommunicated dismissal of the claimants by the defendants, which is also in breach of the public service rule, is unlawful, null and void and of no effect whatsoever, and same is hereby set aside. I so hope. Accordingly, relief 1 in the amended complaints succeeds. The law is firmly established that where the court declares a dismissal null and void and ineffectual, the appropriate order to make in such a circumstance is reinstatement of the public officer because the contract has statutory flavor. See the following cases: Kwara State Judicial Service Commission and Tolani Supra, particularly at pages 28 to 34, because of Olatobos and ISAF citation provided. This position of the law was captured in these illuminating words expressed by Caribbean White of blessed memory in the case of Olani and University of Lagos Supra. I quote, "Logically and judicially, there seems to be no basis for doubting the validity of the proposition that reinstatement is the correct remedy for an ineffective and invalid exercise of the power to dismiss. This is because the appointment having not been validly terminated, the position remained unaltered by the ineffective purported exercise of the right to dismiss," unquote. In view of the finding of the court that the purported dismissal of the claimant is unlawful, null and void and of no effect and thus set aside, this court makes the consequential order of reinstatement of the claimants to their positions as if they never left. Thus, relief 2 in the amended complaint also succeeds. I would take reliefs 3, 5, and 6 together for the reasons that, in view of the status of claimants' employment, they go hand in hand. The law is tried that an employee whose employment is unlawfully terminated or ended is entitled upon restatement to be paid all his salaries and allowances as if he never left the employment. See the case. Again here, the notorious case of Bolani and University of Lagos. Sorry, Leonard Council, can you hear me? Can you hear me? Can you hear me?
Yes, my lord.
Very well. I will start again. I'll continue from where I think I stopped. It is important to point out that in an action for wrongful or unlawful termination or dismissal, only two primary issues call for determination. They are whether the termination or dismissal is wrongful or unlawful, and two, what is the measure of damages recoverable, where the termination or dismissal or retirement is found to be wrongful or unlawful. See the case of Imonike and Unity Bank PLC, citation captured. This court have found that the purported uncommunicated dismissal of the claimant is unlawful and thus set aside. The question then goes to the measure of damages recoverable. What then is the measure of damages recoverable when an employment with the state statutory flavor is found to be unlawfully determined? The Supreme Court, Pelnoya GSC, CGM retired in the case of Ikiagwa, Nigeria, and another, held us, I quote, I am, however, not unmindful of the fact that where a plaintiff seeks the relief of reinstatement, which relief is granted, the issue of measure of damages for wrongful termination or dismissal or retirement becomes irrelevant because upon reinstatement, the plaintiff or party is entitled to be paid all his arrears of salary or emoluments, including fringe benefits up to the point or time of reinstatement, and thereafter as and when due and payable, unquote. This means that where an employment with statutory flavor is found to be unlawfully determined and reinstatement is ordered as in this present, the employee automatically becomes entitled to be paid all his arrears of salaries and emolument as if he never left, and as such, the measure of damages becomes irrelevant. Thus, the claimants in this case, who are by Relief 3 asking for an order for payment of the arrears of salaries, cannot be granted Relief 5, which is seeking for general damages. In fact, that will, in my view, amount to double compensation, which the law frowns at. Claimant bid Relief 6, asking for the payment of a sum of 30,657,000 naira as arrears of salaries from January 2016 to June 2022. Facts in support of this were pleaded in paragraph 6 of the amended statement of facts. These facts were not challenged by the defendants in this case. In fact, the Court of Appeal, Ogunmeji JCA, as she then was, now DSC, in the case of Mediora and another Federal Civil Service Commission and others, citation capture, held into earlier that it is only in situation of contract or personal service that the employee may prove special circumstances in aid of specific performance or restatement, which is quite different from the circumstances of that case where it was found that the contract of employment is guided by statute. The court was of the view that there was no need for the appellants in that case to prove any special circumstances to entitle them to the consequential relief of reinstatement and payment of their salaries during the period they were deemed to have been employed in the federal civil service. According to the court, it is not part of the burden of proof required to be discharged by a plaintiff or a claimant in this case, who was an employee in the statutory employment. As such, the court should not unilaterally add what is not legally required to the evidential burden of a litigant. Going by the above decision, payment of salaries upon reinstatement is a consequential relief, which necessarily flow from the order nullifying dismissal. The employee needs not specifically ask for it or prove same. Thus, in the instant case, claimant did not even particularize their claims for salaries as they did in paragraph 6 of the amended statement of fact, neither do they even need to prove any special circumstances to be entitled. Be that as it may, I have perused the documents at pages 225 to 243 of the record, which tends to prove the entitlement of claimants to the sum claimed as salaries in relief 6. I find that they support claimants' amendments in paragraph 6 of the amended statement of facts. Claimant by paragraph 6A and B of the amended statement of facts averred that the first claimant was at the time of the screening was on grade level 16, step 8, and entitled to be paid 223,000 naira per month. This fact have not been controverted by the defendants. It is on record B document at page 225 of the record. It has the approved salary structure for officers in Kogi State, which claimants rely on. That is monthly salary on the grade level GL 16, step 8 is a sum of 223,203 naira 25 kobo. However, claimant in this case B displayed is only claiming 223,000 naira, and which is what the court will grant, as the court cannot grant what the party has not asked for. First claimant is thus entitled to the sum of 223,000 naira as monthly salary, and this multiplied by 78 months, which is a total of from the month January 2016 to June 2026, and that gives a total sum of 17,394,000 naira. The second claimant, read paragraph 6D, was on grade level 12, step 11, when he was also purportedly dismissed by the defendants, and his monthly salary was the sum of 119,000 naira. It is on record by documents at page 225 of the record that the monthly salary of an officer on grade level 12, step 19, is 119,000 naira, 119,562 naira 94 kobo, whilst the second claimant in this case claimed the sum of 119,000, which is a lesser amount. The court will only grant what he has claimed. Thus, the second claimant is entitled to the sum of 119,000 as monthly salary multiplied by 78 months, and that would give a total sum of 9,282,000 naira. The third claimant by paragraph 6F of the amended statement of fact was on grade level 7, step 8, and on a monthly salary of 51,000 naira. The document at page 225 evinces that the monthly salary of a person on grade level 7, step 8 is the sum of 51,526 naira 43 kobo. However, just like it was with the two other claimants, he has only claimed a lesser sum of 51,000 naira per month. The import of this is that the amount claimed by the claimant is the exact amount they were receiving as monthly salaries. Thus, the third claimant is entitled to the sum of 51,000 naira monthly multiplied by 78 months, which is 3,978,000 naira. However, what was claimed in paragraph 6I of the amended statement of facts as regards the third claimant is 3,981,000, which is higher than the actual calculation of 3,978,000. It is tried that the court is only empowered to grant the sum claim where it is proved. Documents on record and the pleadings of the claimants only support the award of the sum of 3,978,000 for the third claimant, and that is what this court would grant. Thus, the first claimant is entitled to the sum of 17,394,000 naira. Second claimant is entitled to the sum of 9,282,000. And the third claimant is entitled to the sum of 3,978,000 naira as arrears of salary from January 2016 to June 2022. It is in view of the above that I find that claimants are entitled to the total sum of 30,654,000 naira as arrears of salaries from January 2016 to the month of June 2022 claimed and proven. In fact, they are entitled to consequential order for payment of salaries from July 2022 till they are reinstated by the defendants. View of all reasons supra, I find that relief 5 fails, while relief 3 succeeds in full and relief 6 succeeds to the extent that the claimants are entitled to be paid the sum of 30,654,000 as arrears of salaries from January 2016 to June 2022. Claimant by relief 4 are seeking for an order of the court for cost of action. Cost was assessed at 800,000 naira. Law is settled beyond peradventure that cost is granted to a successful party and should not be denied except for good reasons. See the case of Bani and Lukoma and 7 of Bottling Company Limited, citation provided. The case of Izen Naka and COP Cross River State, citation provided. The case of Yakuba and Minister Housing and Environment, Bauchi State, citation also provided. Claimants in this case have succeeded in their case and there's no factor necessitating their denial. It is in view of this that I exercise my discretion in favor of the claimants. Claimant in this case assessed the cost at 800,000 as stated supra. However, in view of the number of processes filed by the claimants and the number of appearances had in this case, I award the sum of 300,000 naira to the claimants as cost of action against the defendants. I so award. It will be a disservice. It will be a disservice to the cause of justice, into the enviable legal profession, if I fail as a Judas to end this judgment without commenting on some elementary issues and lapses, notice, and written address of any counsel on behalf of the defendants. A counsel citing authorities cases of legislation owes the court duty to provide policy. He must cite same with clarity, stating specifically the names of the parties, the year of the report, law report and volume, and the part where necessary, and the page where the case can be found. See the case of Mobile Producing Nigeria Unlimited and Edwin and other citation captured. The case of Chidoka and another versus First City Finance Company Limited, citation provided. The case of Ogudo and the state citation provided. In the instant case, learned counsel on behalf of the defendants in paragraph 2.6 of his final written address cited notorious Lucas Classical's case on jurisdiction, the case of Madukoli. That's the way he cited this, Madukoli and others versus Kim Dili. The case is cited in that law report as Madukolu. The correct citation is Madukolu and others versus Kim Dili. And it's a 1962 case of all Nigerian law report. In 581 all, it is also reported in 1962 to Supreme Court of Nigeria Law Report. Equally in paragraph 3.1, he cited the case of Ayola versus Pedro. 2014, Nigerian Weekly Law Report, page 409, without stating the volume of the said law report or what part of the said volume it can be found. Where a counsel cites a case without clarity, the court is at liberty to ignore same. This is because the court cannot be sent on a wild goose chase. When one appreciates the tedious and delicate nature of the judge, counsel representing parties must take every care to lessen or facilitate it and not to increase it. For the avoidance of doubt and for the sake of clarity, I declare an order as follows. 1, that the purported dismissal of a claimant is null and void and thus set aside. 2, claimants are entitled to be reinstated to their respective positions for the without laws in rank as if they never left the employment. 3, claimants are entitled to the sum of 30,654,000 naira as arrears of salaries from January 2016 to the month of June 2022, the breakdown of which is at paragraph 29 of this judgment. 4, claimants are also entitled to arrears of salaries from July 2022 to when they are reinstated. 5, the cost of 300,000 naira is awarded in favor of the claimants. And 6, this judgment is to be complied with within 30 days from today, failing which it shall attract 10% simple interest per annum. Judgment is accordingly entered.
As a copy.
So copies of this judgment will be forwarded to Lokoja for counsel to have copies.
As a copy.
And I need to tell you, correct one thing. When counsel filed the complaint, counsel in the release was referring to wrongful. Whilst in the argument in the final written address, counsel was arguing that this is statutory employment. And in statutory employment, there's nothing like wrongful, it's unlawful. It's against the statute. Breach of it is against statute. So it's only a master-servant relationship that you use the word wrongful.
As a copy, I'm grateful, sir.
Even counsel in this courtroom to take note of that.
I'm grateful, sir.
There's a difference between wrongful termination or wrongful dismissal and unlawful termination or unlawful dismissal.
As a copy,
when an employment is flowed with statutory flavor, it is unlawful. Any breach is an unlawful breach. It's only when it is master-servant, I reiterate, that it's wrongful.
As a copy, please. My Lord, we are grateful. I seriously did not know this. I'm very grateful and I appreciate the court, sir. And I sincerely apologize for the stress and the work that we gave me, Lord, to do, sir, unnecessarily, sir. We are sorry. We are grateful.
Arise from Lokoja.
As God pleases.